Hello, and we want to thank everybody for being on this call today, titled Top 12 Employment Law Issues for Dental Practices, hosted by Monica Rebella, CPA, President of Rebella Accountancy, with our special presenter tonight, Anita York of Scott & Whitehead. Anita and Monica, welcome to the call.
Thank you.
Thanks, Jeff.
I think we're ready to get started. Just a few housekeeping items. If you're on the call live today, Anita will be presenting several slides that you can view the webcast link, and that was in the registration and reminder emails that we sent you. If you click on the link, you'll see 4 buttons in the upper left-hand corner of the page. You can click on the View Slides button and sync them with either the phone if you're listening on a phone call live with us, or on the webcast, you can use that button too. If you have any questions, you can also submit those with the Submit the Question button, and if we have those that come through during the call, we'll answer those towards the end. And I think we're ready to start. So again, Monica, welcome to the call.
Well, thank you, Jeff, and just wanted to thank everyone again for being on this webinar tonight. It's in the evening, so we appreciate your time to take a few minutes to be with us this evening. Anita, before we get started, why don't you tell us a little bit about your practice and your background?
Hi. Monica, as you know, I had a life before going to law school. I spent about a dozen or so years in management. The nice thing of which is that means that I have some idea of what goes on out there in the real world, which has been terrific when I'm working with clients, particularly with sticky issues. At some point in my management career, I decided it was time to go back to school and decided to go to law school. For the last 17 years, I've been an attorney, and I've always specialized in employment law, which is a field that I felt like I knew a little something about, having spent some years in business. And in the meantime, for the last probably 5, 6, 7 years, I have had truly the enjoyable experience of being able to work with about 150 or so dentists on the various issues. So hence this evening's program specializing in the employment law issues that I see most often with our dental clients.
Well, I think that you see them more often than I, but I certainly get those phone calls from time to time. So we appreciate your time and being here with us tonight after hours. Well, I'm going to turn it over to you. You're the expert here, and I'll jump in where I can.
Sounds terrific. So what we're going to do for the next hour or so is we're going to take a very quick look at the top 12 employment law issues that I see come up. And so if you do the math, that means we're going to spend about an average of 5 minutes on each topic. Needless to say, we're not trying to do a broad explanation of any one topic, really just trying to introduce some of the things that I see most frequently. So I've broken these down into the following 4 categories. First, we're going to talk about hiring procedures. I'm going to give you some tips, some warnings, some things that I see. We'll spend a few minutes on that. Once we finish with that, we'll go to our second category, which is actually the employment relationship itself. So you've hired somebody on board now. We're going to talk about how to manage your staff that hopefully will help improve your ability to manage your practice the way you want. Third, we're going to talk about critical wage and hour issues and mistakes, because these can be among the most costly mistakes. And fourth, we're going to have a brief discussion just about a couple of leaves of absence and reasonable accommodations issues, because although I didn't used to see these come up very often, it does seem to be the claim du jour these days for plaintiffs' attorneys looking for some reason to sue an employer. And with all the various leaves of absence and leaves of absence rules, unfortunately, it can be pretty easy to make a mistake in those areas. So with that said, let's get started. Go ahead and go to the second slide, please. Let's start with the hiring process. The first thing I want to talk about is classification in a couple of areas that I get a lot of questions on, and that is the following. How do we deal with working interviews? How do we deal with temps? And what's the difference between those two things and a regular employee? So, working interviews. Under the law, time worked means the time during which an individual is subject to the employer's control. In other words, you're telling them what you want done, and they're doing it. An interview, on the other hand, is a formal meeting in which generally you are exploring the possibility or evaluating the possibility of that individual working for you. So, as you can see, those are two very different things. question I get, however, oftentimes with dentists, and quite understandably so, is they want to do a working interview. Working interview, what is that? How can we do it in a lawful way? Here's what my recommendation is. If you're having an individual come in to do a working interview, I recommend no more than 1 day. And I understand that that's not a long time to evaluate the person, but this is a working interview. It's really just supposed to be an extended interview in which you're having them do something to let you know, do they have an idea of what to do. So perhaps you might have an assistant take some x-rays of one of your staff members. You might have a hygienist clean the teeth for one of your staff members. They're not really performing actual services on a patient, but you're just trying to get an idea of what their skills are. You might even have a front office person answering some telephones. But you don't really want them performing actual work, or they're really an employee, even if only for that 1 day. So here's my recommendation. In terms of compensation, always pay them for the day. I don't care if you pay them minimum wage, which currently is $8 an hour. That's perfectly fine. Have something in writing. We're going to do a 1-day working interview. I anticipate that you'll be with us for 4 hours. During that time, you'll be paid $8 per hour. I'll give you a check before the end of the day. And then do that. If they work any longer than that, make note of that. Make sure you pay them, or pay them more than that, whatever you wish, but do pay them for the day. There actually has been a lawsuit where an individual, she was actually a hair model, so a little bit different context, but where she worked for 1 day, she was paid a couple of weeks later. The rule is when somebody no longer works for you, they must be paid that day. And in that context, the individual actually got penalties because she wasn't paid that day. So write the check that day. What are the risks? There's two. One, Monica can certainly speak to, which is it is certainly possible that some taxing authority could say you didn't take taxes out for that day. Say you didn't report it as income, you didn't pay taxes on it. If you're paying a small amount, that risk has got to be incredibly minimal. Monica, would you agree?
It is minimal, and if people get audited and they will look at money that you paid to fees paid others or just individual names, they'll look through and find that. But typically it's going to be under $500, and so there's no 1099 needed, and it's too small for them to pick up as wages if that's the only thing that you've ever paid that person. Perfect.
Okay. So then if that person comes on as an actual employee, maybe there's a different classification we should be using. The second risk is this, and I've never had it happen, but I suppose someday it could, and that is that person actually incurs some injury that day. A needle stick, hurt my back, I fell, whatever it is. And in that case, you actually want them to file a workers' comp claim rather than suing you in a civil lawsuit. So in that case, you actually prefer them to be an employee. I don't have time to go into a lot of details about that, but trust me, that is the case. So working interviews, be careful, keep it short, 1 day, preferably no more, and pay them for the day. The second thing I raised was the issue of temps versus regular employees. We have a lot of dentists who hire individuals, and when they first hire them, they hire them as temps. Along the same lines as a working interview, it's really not following with what the definitions of the words are and what the definitions under the law are. A temp is somebody who's a temporary person. I'm sorry, Jeff, please go to the next slide. We should be on slide 3 at this point. A temp is someone who is a temporary individual, therefore a specific purpose. So they might be there to cover a pregnancy leave of absence for a few months. They might be there to help you transition from a paper organization to a paperless organization and get your charts input. They might be there for some other reasons, but they are always there by definition with the intention of it being a temporary position. Let's go to the next slide. A regular employee, on the other hand, is somebody who you hire with the intention of that individual being there indefinitely. There is no intended deadline date by which they will no longer work for you or deadline event that will trigger the termination of the employment. The goal, in fact, is that they will be with you in the long run. So what this means, let's go to the next slide, is that a temporary individual, a temporary worker is not the same thing as a regular employee. A temp is someone who is hired for a temporary position. A regular employee is someone who's hired for a regular position. When you hire somebody new, they are still a regular employee, but they are a regular at-will employee, and certainly you are evaluating them in those first few months. That's what you should always be doing, but that doesn't make them a temporary employee. They are still a regular employee. So make sure you have good at-will language. We'll be talking about that a little bit at the end in terms of an employee handbook. And then if that person is not working out in the first 30 days, 60 days, 90 days, evaluate them early. If it's not working, terminate them early. I have had employers call me and say she's been here for a year and a half. She's never really done well. Well, then she shouldn't have been there for a year and a half. Let's go ahead and go to the next slide. So that's the first part of your hiring procedures, really, in classification issues. The other classification issue, though, that I want to just mention, and Monica certainly has plenty of experience with this, is the idea of independent contractors. For many, many years, it has been the long-standing practice that associate dentists have been treated as independent contractors. This was accepted. It was not challenged. Everybody knew that it was okay to do. The reality is that as a matter of law, there are rules about who qualifies as an independent contractor, and an associate dentist has never really fit those rules. But for a variety of reasons, it really wasn't challenged. Those reasons include possibly the independent contractor was incorporated, so it wasn't an issue. That also includes the possibility that because associate dentists tend to be higher level, they're higher paid, there was a sort of assumption that they can take care of themselves and they don't really need government stepping in to protect them. Well, things have changed. In the last couple of years, we've seen a few things happen. First, there have actually been some new statutes that talk about independent contractors and misclassification. But in my opinion, more importantly, and it won't be surprising to any of you, the taxing agencies need more money. They're looking for revenue sources. And one of the sources that they've hit upon is misclassification of individuals who are classified as independent contractors, but who in fact, as a matter of law, are employees. And they have come to realize that this applies to many associate dentists. And in fact, those folks are oftentimes highly paid, so the taxing agencies get even more excited because there's even more possibility of penalties. So, Jeff, I'm not sure where we are on slides. We should be on slide 6.
And
the bottom line,
to put a point onto that, Anita,
yes,
is that the penalty is large now. There used to be penalties for it. They were very small, and they could be mitigated if the people would be willing to show that they paid their own tax on it. Now the penalty is $5,000 every time you get it wrong.
Got it.
So the penalties are very steep. So it's time to pay attention to this. I think we all skated by saying, look, basically they're professionals. And as a professional, they don't need to be supervised, and you can actually say, well, I gave them my days. But now it's dollars are there. It makes economic sense that you pay attention to it. There are ways to do it properly, and I have those if anyone really wants to know how to do it and get it in place. But for the most part, there really isn't anyone that's an independent contractor in a dental office unless you follow these particular rules, and there are some ways to do that. Yeah,
perfect. So here's typically what I try to explain just so that you can sort of wrap your head around the context of how it works. We're on slide 6, and it says, independent contractors are in business for themselves. Associate dentists are not usually in business for themselves. So if you think about it in the context of a solo practitioner who rents space with you or shares space with you, a space sharing arrangement, in that case you have 2 dentists, each of whom has their own practice, each of whom has their own patients, who bills their own insurance, who bills their own patients, who does their own collections, sets their own schedules, sets their own prices, determines their own discounts. All of that, by definition, means you are in business for yourself. That kind of person would be considered an independent contractor, even if, let's say when they rent space from you, they also are using your staff. Let's say that they pay you to do some billing for them. They pay you to have the receptionist answer their telephones. But they have a separate practice. They have their own business cards. They have their own business entity. They go to CDA. People know that they're a different practice than your practice. That looks and feels very different than an associate dentist who works for you, works in your practice, sees your patients, you do the billing, you do the collections, and you pay that person for their work. So even where you say that that individual sets their own days, goes on vacation when they want, works as many hours as they want, under the law, and Monica's right, there are absolutely some exceptions, but under the law, most of the time, those folks are going to be considered actually employees by law. So let's go ahead and go to slide 7. The primary considerations that the agencies or even the court will look at are the following. The right to control is the primary one. In the example that I just described with the space sharing arrangement, one dentist does not have the right to control the other one in any way, shape, or form. Your associate dentist, however, you do have a right to control. Now, you may not exercise that control, and frankly, that's not the issue. The issue is that you have a right to say, I know you've been working Mondays and Wednesdays, but I want you to change it to Tuesdays and Thursdays. Or you have a right to say, I'm going on vacation the month of March. I need you to cover for me. Or you have a right to say, I need you to take care of my patients on Wednesday. I'm not going to be here. So that's the issue really, is you have the right to control what they do. You determine who their staff is. You determine what pricing they charge. You determine what discounts are going to be provided. And, in fact, you may even sit them down and have a talk with them when their performance is not good, when their treatment is problematic, when you're seeing too many retreatment needs. You're going to actually sit down with that person and be not happy with their performance. Again, in a space sharing arrangement, it's not your issue, not your deal. So that's really the kind of thing that they look at in determining right to control. Some of the other primary factors, are they providing the exact same service that you provide? Are they associated with the practice? In other words, they are considered by the public to be part of your practice. And again, there are many other factors that we look at, but for the most part, I really just want to plant the seed this evening that if you have associate dentists who are classified as independent contractors, it's a red flag now for the taxing agencies. Talk to Monica, talk to me, talk to somebody, and see if there's something you should be doing about that. Okay, let's move on to slide 8, please. The next topic, employee classifications. Do want to emphasize, I've already mentioned it, if the associate dentist is incorporated and there's a written contract, is that sufficient? It used to be sufficient. In fact, I had a client go through an audit with a different CPA recently, and the practice was incorporated, the associate dentist was incorporated, everybody agreed it was an independent contractor, there was a contract in place. The EDD came back and said, no, that is an employee, and even having the contract in place and both corporations did not work anymore. It used to work, it doesn't anymore.
No, that's not going to cut it. There's a lot more that has to be done, and it can be done, but it takes work, and people have to realize if you want to go this direction, then it's going to take work more than that.
Right, and you really have to be willing to let go of control and let that person run their business the way they want to run their business. They get to set prices. They do collections. They really, even though they're part of your practice, physically they're running their own business. Okay.
Well, there is some part about the fees and billing the insurance company that can be done differently, but again, it's very specific.
Yeah, you're exactly right. Okay, so that takes us through our first category, which was hiring procedures, tips, issues. So our second category is really the employment relationship itself and managing your folks. So let's go please to slide 9. The first thing I want to talk about is bringing the person on. Oftentimes you have an opening and it just feels so overwhelming knowing that you have to figure out how to find somebody, how to hire them, is it going to be the right person? So I just want to give you a couple little ideas that might help you hopefully narrow out the not so good candidates and get yourself hopefully a good fit for your team. And that first recommendation, believe it or not, is not just read the resume, but really, really read the resume. It has been my experience, even in our own business, that I'll read a resume, somebody looks good, we do the interview, we go through the whole process, decided they aren't quite a good fit. I go back and look at that resume again, and sure enough, if I had really analyzed it carefully, I might have realized much sooner that it wasn't going to be exactly the right fit. So really do look at it, figure out if it's going to be a good fit. Are the specific skills and the level of experience directly related to what you need? Is it well written? Maybe that matters to you, maybe it doesn't. In our business, it matters a lot because we spend our days writing things and we need people who can write well. Are there errors? Again, you can decide if that matters to you or not. The one thing I always want you to pay attention to is, are there gaps in the employment history? Look at the timeline. If there are gaps, figure out why. We had a candidate come in a few years ago. She had a 1 year gap. When we asked her about it, she said, the agency typed the resume. They must have made a mistake. Well, in doing reference checking, it turned out she actually spent 1 year in prison for embezzling from that employer. So there was no mistake. And we actually really liked her and might have extended an offer to her if we hadn't figured that out. So look for the gaps, pay attention to them, and get to the bottom of it. Okay, so if you are interested in considering the individual, note the areas on that resume for follow-up, because that's going to be really good areas for you to talk about when you're doing the interview with her. So let's please go to the next slide, slide number 10. And now you have decided through the resume you're interested. I always recommend a telephone pre-screen before you bring the individual in. 5 or 10 minutes on the telephone may tell you all you need to know for ruling somebody out. It's certainly not going to tell you all you need to know for hiring somebody, but you can save everybody a lot of time if in that telephone interview you decide, that's probably not the right person. So when you're making those notes on that resume, note a couple of things. Those are good things to mention in the telephone pre-screen, and really all you're trying to do here is get a feel for the individual, particularly if they're going to be a front office and going to be on your telephones. How do they handle a telephone call? How do they speak? Is that the image that you want being given for your practice? But also, if there's something in the resume that is you're just not quite sure if it's going to work, bring that up right away. I interviewed somebody about a week ago who I really felt was very overqualified for the position, and so I just said that right up front. It seems like you have so much more experience in large organizations than the one that is considering you. Tell me why you think you might be interested in going to a smaller organization. So I just put that right on the table. So you've done a telephone pre-screen. You've decided that you're interested in having the person come in. We're going to now do an in-person interview. Please go to slide number 11. You bring them in. I like having everybody fill out an employment application. Even though they've probably brought you a resume, I want them to do an application. And I want to do that for a couple of reasons. One, I want to see if they follow rules. Will they fill in all of the blanks? Or do they just think that it doesn't really apply to them and they don't need to? Secondly, I want to see is it going to match what is on the resume. And third, there may be things on my employment application that, frankly, they haven't put into their resume. Maybe they've intentionally not put into their resume. So I sort of want to force them to give me the information that I really want to see. So they might spend the first 15 minutes or so completing your employment application. Bring them in. I recommend that you interview them first. Spend whatever time you think is appropriate. Sometimes in 15 minutes you can decide it's not the right person. You thank them. Let them know you're looking at other candidates also, and you'll get back to them, and you just move on with your day. On the other hand, if it's somebody who you are interested in, I recommend that you consider allowing your employees to interview the individual. Before we get to that, let me finish. When you're interviewing them, briefly describe your practice in the position. Don't go into a lot of detail. Really, the purpose for that person being there is for you to decide, are you interested? But obviously, you want to let them know what kind of practice it is, what kinds of things do they do in that particular position. Ask questions from the resume. Ask open-ended questions so that you get that person talking in a conversation. That's going to give you the best feel for who they are and whether they're going to be a good fit. Ask the candidate if they have any questions, certainly. We're always concerned about impermissible questions. The Department of Fair Employment and Housing is an agency that enforces, among other things, discrimination laws. Most of what they do is very pro-employee. However, they do have one document that I really like. You can Google it, DFEH 161, and it's actually a 3-page document that gives you a good explanation of what you can ask, what you can't ask in the various categories. That'll give you some good insights in terms of staying out of trouble and not asking the wrong questions. Okay, moving on to slide 12. As I mentioned, I like having staff also interview the individual. This can be a 10-minute sit-down, but oftentimes what happens is the individual will relax with your staff where they didn't necessarily relax with you. Staff can do 2 people at a time. Let them know what not to ask just so that they don't get you into trouble inadvertently. You might even give them some ideas of things to ask. Let them look at the resume and then really find out from each person what they felt. We had an interview here once where every interview loved this person and every staff member said she was arrogant and treated them as though they were subordinates in that time. So you might learn some things about whether that person is going to be a good fit for your team, which frankly can be far more important than whether they have the right skills. Skills can generally be taught. Being a member of your team who fits well generally cannot be taught.
So, Anita, if you're going to have the staff interview the person, you're going to want to go back to that prior slide and also make them aware of what they can't ask.
Absolutely. Give them a copy of DFEH 161. It will make them feel more comfortable, frankly, in knowing what they cannot ask. And again, you might even give them some sample interview questions just to make them more comfortable, because chances are they've never done this before. That's what we've done here, and our staff is so used to doing these things now that it's just second nature to them. So, you're absolutely right. You don't want them getting you into trouble by asking questions that they shouldn't be asking.
Right, because that'll put the doctor right into the same position as if they had asked it themselves. So.
That's exactly right. Moving on to slide 13. Background checks. I get asked about this more often than I used to because more and more employers are doing them these days. And I think that's probably because they're so much easier to do than they used to be, and they're not that expensive anymore. But there are many, many rules that apply because you are now invading that person's right to privacy. So my primary piece of advice here is use a good company. Don't internet shop for the cheapest one. Look for a very good company. They are out there. Ask who other people are using. You can call me and I'll talk to you about what I know. I'm not going to do it on a public forum, but there are things to be looking for, and the primary one is the second bullet point in this slide, which is there are specific notices and specific consents that must be given. California rules are different than everywhere else, of course, so you want to make sure it's a company that understands that they must also be complying with California law. If you make a decision based on in any part on that report you get, the individual has a right to a copy of it, and in fact they're told that in the consents that they give, and they have a right at that point to say, I want a copy of the report. Last but not least, do not use the information unlawfully. So, for example, it is possible to get a workers' comp background check. I recommend that you never do so. I understand how tempting it is. I understand that you want to know if they've had those claims before. But remember, that candidate is going to know that you got that report. And if you don't hire them, you better be able to prove that you hired a far superior candidate so that you will not get accused, or at least you'll win if you are accused, of discriminating based on a workers' comp claim. So my recommendation is don't even get the information. Just go based on what you have from meeting with them, from interviewing them, from doing your reference checks. Please don't skip reference checks. It's very important to do them. You'll be surprised at what people will tell you. And in the background checks, only use information properly.
So, Anita, if you have a potential candidate, and you had mentioned earlier, don't miss the gaps in employment.
Yeah.
And they voluntarily say, I went to jail.
Yeah.
And that makes you uncomfortable, and you certainly can't use that for discrimination. You just have to prove that you did hire a better candidate.
That's a really good question, Monica. And if I led you to believe that, I misspoke, and I apologize. You are allowed to use criminal convictions if they're related to the job. So, in my opinion, honesty is always related to any job. In my opinion, violence is always related to any job. On the other hand, drunk driving, if that person's never going to drive for you, it's not job related. If you have a front office person who is going to be handling money, anything related to honesty becomes even more important because they are going to have access to potentially stealing from you. You really want to look at, is it job-related, and if you can justify a conviction as being job-related, then you are absolutely allowed to consider that. There's a few other factors that are considered, like how long ago was it, how serious was it. There's some other things to look at. So if that comes up, probably have a conversation with your attorney. But, yes, you are allowed to use convictions, not arrests, though.
But it has to be related to that job. So if it's unrelated to that job, you just better talk to your attorney about it and make sure you're documenting that you found someone more appropriate for the job.
Exactly. Okay. Find somebody with more experience or more directly applicable experience, or who is willing to take the job for what you want to pay. Maybe that other person wasn't. Look for some things that are really what we call articulable, black and white, very clear lines of why you chose that person. Okay, so you've decided to hire the candidate. They've jumped through all the hoops. They've made it through everything. You've decided to hire them. Let's do a quick look at some of the documentation that we want you to be using. Let's please go to slide number 14. And we're going to first look at the documents that we've already mentioned. Employment application, I want them to fill that out. They're probably going to give you a resume. If you're doing background checks, make sure that you have all of those documents. And reference checks, make sure that you're documenting who you've spoken to, what they've said, to the extent that that is applicable. Slide 15. The following documents are required. Some of them won't be a surprise to you, but the first one may be. As of January 1st, 2012, we have a new law called the Wage Theft Protection Act, which relates to nothing as far as I'm concerned, but that's what it's called. Under that act, the Department of Labor Standards Enforcement, which we all know as the Labor Board, has published a form called Notice to Employee. You can Google Notice to Employee 2810.5, which is the Labor Code section that provides for it, and that form will come up. You are now required to complete that form, provide it to the candidate, or then you can do it on the first day of employment. I always do it with the offer letter, though, and they must sign it. That's now required by law. It's not required for anybody who's hired prior to January 1st, 2012. Everybody January 1st, 2012 and beyond, it is required for. I-9 form, it was revised earlier this year, so if your form in the lower left corner, it will have a revision date. If that date is prior to 3/8/13, throw those blank forms away. Don't use them anymore. Google I-9 form and start using the new one. You do not redo I-9 forms that you've already done for employees who are already there, but for new hires, you want to be using the new form. Of course, the W-4 form, insurance premium deduction authorization. If you provide group health insurance and the employee pays part of it, you may only deduct it from their paycheck if they have signed an authorization for you to do so. You're required to provide new hire documents related to your workers' comp insurance. Your workers' comp carrier will provide those to you. TB test documentation, numerous other notices which may be provided in an employee handbook and oftentimes are provided in the employee handbook. Slide 16, I also recommend the following documents. These are not required by law, but I do recommend them. The first one is a written conditional offer letter. So generally you're going to verbally tell the person, you know, we would really like you to join us. We're offering you the position of registered dental assistant. It pays $18 per hour, blah, blah, blah. Follow that up with a written offer so that there's no misunderstandings. They sign it. They get it back to you if they've accepted. Again, you can include that notice to employee with that offer letter. If you're going to do a background check, typically we have you include in the conditional offer letter, this is conditioned upon satisfactory completion of the background check. At that point, you direct them to all of the proper notices and consents. I like having emergency contact information for staff. You never know what might happen. Employee handbook, we'll talk about that again. I think it's a key resource for you. Meal period, rest break notices and forms, we're going to talk about that in just a minute, but there's rules that are very strict about meal periods and rest breaks. We're seeing, we have been for years, lawsuits on them, so we want to make sure you cross those T's and dot those I's. Hepatitis B vaccination document is no surprise to you dental professionals.
Hey, Anita, can we go to the written conditional letter for just a minute?
You bet.
Everybody in a dental office is an hourly employee, right?
We're going to talk about that in a minute. Everybody except an associate dentist probably should be an hourly employee.
So when they're writing their offer letters, which a lot of doctors like to say, the hygienist, I'm giving them $375 a day.
Right, per diems. We're going to talk about that in about 10 minutes, but you're absolutely right. That is a big problem. It's a big,
they don't want to
risk.
say that in the offer letter.
Right. Your offer letter should be what the actual pay is based on. So if you're basing your pay on $20 an hour, don't say they're paid $50,000 a year. They're not. They're paid $20 an hour. What they end up earning depends on how much they work, whether they work overtime, whether they have a leave of absence, etc. So, yes, we want you to put down exactly the basis of their pay, and obviously we want you to do it in a way that's compliant with the law, which I will talk about.
Okay, thanks.
Yeah, absolutely. Okay, so we've finally hired the individual. We've got them on board. Let's talk about managing them. And I'm going to take a pretty quick race through this. This is normally about a 2-hour program in and of itself. But here's the bottom line. I'm sorry, we should be on slide 17 at this point in time. I train employers of all types and sizes in what I call active management, because it really is across the board the way to make your workplace hopefully be what you want it to be. And the bottom line is this: you are the boss, you should be the boss, but you should be a good boss. So let me explain what I mean by that. I use what I call the 3 strikes rule, and the concept is this: if you follow these rules, chances are pretty good that you're going to have a decent workplace, decent communication with your staff, and hopefully you're going to stay out of hot water. If you don't follow these rules, 3 strikes and you're out. And if there's going to be a challenge such as a wrongful termination lawsuit or something along those lines, you truly will be out, because you will not have done the things that you need to do to not only manage your staff properly and well, but to protect yourself. So let's go to slide 17, please. Strike 1, don't wait to communicate. Do it immediately. Do it often. Think about this as an analogy of a parent and a child, and I don't mean to say that you are the parent and your staff are your children. I absolutely do not want you thinking that way. But just for purposes of analogy, if you are not communicating with your children about what they're doing good and what you expect and what they're doing poorly, then they really don't have any way of knowing for sure, and they're going to go off to do whatever they want to do, and at some point you'll just get mad about it and they'll be confused. So communicate immediately, and frankly, if you are communicating immediately, you will be communicating often, because there are multiple times in a day when it occurs to you, oh, wow, she did a great job with that patient. Oh, that phone call sounded really good. Oh, my gosh, I can't believe that she did not change the equipment as quickly as I wanted her to, and I'm sitting here waiting. Whatever it is, you might be thinking it, communicate it. Sometimes it's appropriate to do so privately, so I'm not saying it needs to be done in the open office where everybody's listening, but communicate immediately. Chances are you will be communicating often. Slide number 18, strike 2, failure to document. I want you making notes of things that are happening, and by this I mean the good, the bad, and the ugly. So communicate verbally, tell them what you tell them, and then make a note of it. It does not have to be a dissertation. It does not have to be a long written thing. It can be a note that you type in your iPhone. It can be an email. It can be a note that you write somewhere on a journal that you might keep. Whatever system works for you, find the system and do it. Document the good, because even with bad employees, you look far more credible and far more fair if you say, yeah, she did some things incredibly well. The patients loved her. But at the end of the day, it didn't matter, because she made so many mistakes and she took so long to get through each patient that it just wasn't working. We were running 45 minutes behind each day. I was having to decrease my production, and I was having to do retreatment. So the patients loved her, but that wasn't enough. You sound very fair. Don't be afraid of even giving good praise to a to a bad employee. Clearly, we want you documenting the bad. When someone calls me and says, she's been a bad employee for a year and a half, I want to fire her, I ask them, tell me what's going on. They tell me, okay, so when did that happen? I'm not really sure. Well, did you document it? No. So there may be a year and a half of bad behavior. They haven't documented anything. Chances are that's going to be a risky termination. So document the good, document the bad, and clearly we want you documenting the ugly, which is really just the really, really bad. That's going to be the most important stuff that you make sure you get documented. Slide 19, strike 3, failure to give written warnings. This is obviously related to the bad and the ugly. Eventually we get to the point where that warning is a shape-up or ship-out final warning. Want to make sure that you're doing that in writing so that if the time comes that that termination is challenged, you can say it was fair because I gave that person every opportunity to know what I expected, to know what needed to change, and it didn't change. And the bottom line is this: when you get to the point that you're terminating the employee, hopefully what you can say in that termination meeting is something along the lines of, I've counseled you about issues over the last few months and have not seen the necessary improvement, therefore your employment is ending today. That's not the time to go into a long discussion, and by that I mean a back and forth discussion about what the issues are. The employees should not be surprised. They may be unhappy because they thought they were doing well, but you have communicated to them, hopefully in a written warning, what you expected, what the problems were. That certainly does not apply in every case, and I'm not trying to suggest that it should. There are times when an employee does one thing that is severe enough that you fire them immediately that day. There's no warning. There's no discussion. Boom, that's the end of it. I'm not suggesting that you should not do that. But in general, where there's ongoing performance issues, I want you doing a final written warning before you do that termination. It will absolutely save you if there's ever a challenge, and it might even help you to win a claim for unemployment benefits, although there's no promises there. Okay, Category 2, that pretty much covers it in a very quick nutshell. Let's move on to our critical wage and hour issues. These can be among the most expensive claims of all. Let's please go to slide number 20. We talked about classifying employees as a variety of things already. I mentioned independent contractors, working interviews, temps versus regular employees. Monica's already raised the issue that I'm going to talk about next, which is exempt versus non-exempt. This is a long discussion, so I'm just going to get to the bottom line here, which is this. An exempt employee is someone who is exempt from the wage and hour rules. You don't pay them overtime. They don't keep timesheets. They don't have to get meals and rest breaks that are recorded or even get them at all, frankly. They are paid as an exempt employee. The wage and hour rules don't apply. There's special categories that apply to that. Everybody else is by default a non-exempt employee, which means they're not exempt from the wage and hour rules. Please go to the next slide. So, who is potentially exempt? The very short answer is dentists. That is probably it. Now, one exception is if you have a larger practice, probably at least 25 employees, so that you have an individual who is something like a business administrator, a true office administrator. They're not the person who's sitting up at the front desk, answering phones, scheduling appointments, taking money, and who also happens to be considered the office manager. That is not an exempt employee. A true manager, an exempt manager, is spending at least half of their time managing the practice, managing the staff, not doing the work that everybody else does. So, as Monica mentioned, primarily your only category is going to be dentists, not hygienists. They are never exempt unless they fit into the manager category, but that means they're not practicing hygienists. That means that they're managers. In order to be a exempt employee, even for dentists and managers, there's a second requirement, which is a minimum fixed salary of at least $640 per week or $2,773 per month. By the way, I'm sure you all know that July 1st, 2014, we have minimum wage increasing. January 1st, 2016, it increases again, $1 per hour each of those times. When that increases, this minimum fixed salary will also be increasing, so just be aware of that. So, dentists are very, very often paid on a production or collections basis. That does not qualify them as exempt. And believe me, you don't want them keeping timesheets and getting paid overtime. So what you need to do to make it work is have this minimum fixed salary and then pay them production on top of it. At the end of the day, it works out the same financially. It's all in how we draft the contract so that they're guaranteed this base salary as long as they work. If they don't work, you don't have to pay it. Daily per diem is unlawful for dentists or hygienists or anybody else. It's not, it doesn't make them exempt, and it's actually not lawful. So there's a lot more to the exemptions for non-dental employers, which we're not going to talk about today. Slide 22 takes us through just an explanation of everyone else who's not exempt, which is, again, hygienists, assistant, treatment coordinators, your front office, everybody, including your managers, unless they're spending at least 51% of their time actually managing. Okay, so what does it mean that somebody is a non-exempt employee? On slide number 23, I take you through the 5 primary requirements for all non-exempt employees. They must be paid overtime, and for that reason, they should be paid hourly. I'm going to talk about that a little bit more in a minute. They must be provided a non-working meal period of at least 30 minutes. They must be provided non-working rest breaks, 10 minutes in the morning, 10 minutes in the afternoon. They must keep accurate time records. They must receive pay stubs with required information. We're not going through all of these things tonight. I really want to focus on number 1 and number 3 because these are the primary areas that I see dental practices making mistakes. So let's go to slide number 24, please. Non-exempt employees must be paid overtime. You can pay them a salary if you want. So if you want to pay somebody $1,000 a week flat salary, that's fine, but you still must pay them overtime. So for that reason, if they're a non-exempt employee, you really are hurting yourself by paying a fixed salary plus overtime, because then when they work less than their 8 hours a day or their 40 hours a week, you're not taking the benefit of paying them less when they work less, but you're still having to pay them overtime. So in most cases, since you have to pay the overtime, you want to pay on an hourly basis. Secondly, as Monica mentioned, you're permitted to pay a daily per diem, but the whole point of paying the daily per diem is so you're not paying overtime. You still have to pay overtime. So again, the concept is you should probably never be paying a daily per diem and overtime. That just makes no sense.
Well, what are the daily per diem, if they do it and you divide it by the hours, as long as it's over minimum wage, they can do it. They just don't want to state it in their letter, right?
I'm not quite sure what you're saying.
If their daily per diem amount that they pay the doctors, even though you said it was unlawful, as long as it's minimum wage for the hours, they can pay that. But like you said, they will have to still pay overtime.
So daily per diem usually means, like you said, $350 a day or $400 a day. I'm going to use 400 because it divides more evenly. So let's say it's an 8-hour day, 400 hours for the day. That means they're being paid $50 an hour. If you pay a daily per diem and that person happens to work more than 8 hours, then you have to break it down to the $50 per hour. That means the time and a half overtime is $75 per hour, and you still have to pay the overtime at that $75 per hour rate, even though you've paid daily per diem.
Right.
So, yeah, that's the problem with it. Mandatory overtime if somebody works more than 8 hours in a day or 40 hours in a week. We see a lot of errors where people think it's just the 40 hours in a week, and it's not. It's either one here in California. Most states it's just 40 hours per week. Some states have dailies. California definitely has a daily. Is there a way around it? Yes. There is a potential exception, which is what we call the alternative work week schedule. Let's go to page 25, slide 25, please. So, alternative work week schedule, there's a lot of T's to cross and I's to dot, and you have to do it absolutely correctly, but here's the very short summary of how it works. First, you must have a notice and a meeting, and they must be at least 2 weeks before the election. The notice has to have certain information in it. The meeting is to talk about it, let employees ask any questions they may have. You explain it. Then you wait at least 2 weeks. You then have a secret ballot election. That election is of all affected employees, and it has to be approved by at least 2/3. So it's not just a majority, it's at least 2/3. You have to do written notice to the Division of Labor Labor Statistics and Research up in Sacramento. Many employers don't do this, and what that means at the end of the day is that they actually have no alternative work week schedule, and they owe overtime for everything over 8 hours in a day. Acknowledgement is not required, but I recommend it just to make sure that anybody who's a new hire understands what the alternative work week schedule is and cannot later come back and say, I didn't know, therefore I should get the overtime, and I have had that happen. So, again, if any step is skipped, your alternative work week schedule is invalid and you are going to owe overtime. If it's challenged, you will lose. Moving on to slide 26, ever so briefly, minimum 30-minute non-working meal period. I almost never have a problem with this in my dental practices. Slide 27, this is one that is an issue. It's a sticky issue, and I'm seeing more cases on it. Non-working rest breaks. You must provide a 10-minute rest break in the morning and a 10-minute rest break in the afternoon. This, of course, assumes the person is working a full day. It has to be uninterrupted. It has to be 10 minutes. It can't be, I ran back, I checked my text phone, I came back to work, if it's not a 10-minute break. You cannot interfere with it. You cannot discourage it. It's a paid break, so employees don't generally clock out. And there's no waivers. There's no, they couldn't, we were too busy. All non-exempt employees must be permitted and actually able to take the rest breaks, and this is where the rub comes in with dental practices. When we're scheduling back-to-back patients, it is very easy, particularly for back office staff, to say, we had back-to-back patients all day long. There was no way I could take a rest break. So the only two options I've been able to come up with to work around this is, number one, make sure you have staff who are cross-trained just enough to cover each other for 10 minutes. A front office person can break down a room or can be trained to break down an operatory, bring the new patient in, get them seated, get the thing around their neck, ask them the first one or two questions, and tell them someone will be right with them. That can probably take 10 minutes, and now your assistant can come back. Exact same thing with hygiene. This is really where we see more of a problem because there's, again, scheduled back-to-back hourly patients. have an assistant scheduled to come in at 10 minutes when that hygienist wants to take a break. They break down the operatory. They bring in the next patient. They get it set up. They can do that for you. That's one option. The second option is simply stagger patients so that, for example, if you have an 8 o'clock patient and then a 9 o'clock patient, instead of scheduling the next one at 10 o'clock, schedule them at 10:10 or schedule them at 10:15. We out here in the public are very used to medical appointments that are not scheduled on the hour. Dental appointments don't need to be scheduled on the hour either. So there's really no reason that you can't push it back so that you then allot for that time if, in fact, patient appointments generally take an hour. So those are the only two real ways I've come up with, but you really need to make sure that at the end of the day is that your employees realistically are able and do take rest breaks. That doesn't mean they have to take a rest break every single morning and every single afternoon. It means they have to be able to do so. We're seeing more lawsuits and challenges based on that. Okay, so why does it matter? Slide number 28. There are penalties for every violation. If they're not paid overtime, it's all the unpaid overtime plus interest plus penalties plus attorney's fees and costs. For any time they miss a meal period, it's 1 hour of pay per day penalty. For any time they missed anytime you don't provide the ability to take the meal period, provide the ability to take a rest break, it's another 1 hour of pay per day penalty. Plus, if the attorneys found those, they'll probably find other ones. There's probably more violations. You just don't even want to go there. Slide 29, I just want to plant a seed for some other potential wage and hour issues, which is the following. If you pay bonus, overtime is due on the bonus. Call me, call your attorney if you need to talk about that. If you are paying somebody a percentage of production as a portion of their compensation, there should be a written agreement as to that percentage of production plan and how it works. There are issues with on-call and reporting time pay. If you have somebody carrying the cell phone for the weekend for on-calls, there's issues with how that works. Reimbursable expenses, uniforms, sometimes you have to pay for them, sometimes you don't. Continuing education, training, and meetings. Most dental practices, and in fact most employers, don't understand how this works by law, so be aware that that may be an issue. Vacation, sick leave, and PTO have their own rules, and violations of those rules are considered wage and hour violations. Okay, moving on, and we're just going to do a very quick touch on leaves of absence and reasonable accommodations. We are now on slide 30. I really want to highlight two primary leaves. One is pregnancy disability leave, and the other one is workers' compensation leave, because those are the ones that most often come up in dental practices. If you have 5 or more employees, and that includes you, then you are subject to the pregnancy disability leave laws, which say the following. You must allow up to 4 months off for an individual based on disability due to either pregnancy, childbirth, or anything related to the pregnancy or childbirth. That is different than I want to stay home for 3 months after the baby's born. That's called baby bonding time. So for pregnancy disability leave, you must allow the time off. You must give them their job back when they come back, with very few exceptions. But if they want to take extended time beyond when the doctor has released them to return to work, that is entirely up to you. You do not have to say yes. You can make the decision in terms of baby bonding leave. Those are two different things. Workers' compensation leave, doctor's written them out as unable to work because of workers' comp, or maybe the doctor says they can come back to light duty. You do have an obligation to accommodate the light duty, but you do not have an obligation to create a job where one does not already exist in order to give them light duty. So be aware that you have a duty to accommodate, but not give them something that you're now going to be paying extra for a job that didn't already exist. Other medical or disability leave laws, accommodation requirements. There are new regulations regarding pregnancy disability leave and new regulations regarding accommodating other kinds of medical disabilities. They are very detailed. There's a lot of ins and outs of it. If you have a need to deal with that issue, absolutely speak with an attorney to make sure that you don't get yourself into hot water in trying to figure out reasonable accommodation. Is it reasonable to accommodate them, or does it impose an undue hardship? It is actually incredibly difficult to prove undue hardship, so don't just assume that you can say, yeah, it was too hard, I couldn't accommodate. You're always entitled to medical certification if you ask for it for anything that's medically based, so pregnancy disability or medical disability. So I always encourage every employer to require medical certification when somebody wants a leave of absence based on any disability. You're required to also engage in the interactive process when there's an accommodation. Again, speak to a lawyer if that issue comes up. All right. I mentioned earlier that I was going to touch on employee handbooks. Many of the things I've already talked about, I've already mentioned to you, would be covered in a very good employee handbook, and in my opinion, a good employee handbook is an incredibly important resource and tool for you. I'm now on slide number 31. It should provide most of your legally mandated notices. It should confirm your at-will employment status. It should communicate your expectations. It should be customized so that it communicates your expectations. Here's what I want you to do if you're going to be sick today. Here's what I want you to do if you're going to request a day off. Here's what I want you to do if you're being sexually harassed by somebody. It should not just be a boilerplate off the internet handbook that doesn't tell them anything. It should be telling them exactly what you want done in your practice. It should answer their questions if they have a question. They should be able to look to the handbook to find the answer. It should help you as the employer make decisions. Do I give a leave of absence? Do I not give a leave of absence? What do I do? You look in your employee handbook. It should give you guidance. It should also help you to be able to enforce your policies and procedures. And most importantly, from my perspective, because I am a lawyer who defends employers who've been sued, it is important evidence. If you have a good employee handbook, it will be applied with the law. If you don't have one, it will be evidence against you that you don't even care enough about complying with the law to have a good employee handbook. So if you don't have one or it's not up to date, I strongly encourage you to take a look at putting that on your list of things to do sooner than later. And, of course, I do them. I'm happy to do them. Would love to hear from you.
Well, I've got one of Anita's handbooks. I'm going to tell you, getting it done and having all that in there saves you enormous amount of problems when they ask about things. You point right back to the employee handbook and you say, go back in there, it's there, it's documented, and answers a ton of questions you otherwise would have to try and figure out.
Yeah, and oftentimes when we're doing written warnings or letters to employees on leaves, it's just so much better from a legal perspective when you can say, as noted in our employee handbook on page 27, and then you cite your own employee handbook. There's no argument with that. It's in the employee handbook, it's the policy. So last but not least, on page 32, first of all, thank you all for listening. I have no doubt that I have raised as many questions for you as I may have answered for you, and I'm more than happy to talk to you anytime. We do a free 15-minute consultation, and frankly, sometimes that 15 minutes turns into 20, 25. I don't like going much beyond that, but happy to talk with you about any questions or issues you may have in a free initial 15-minute telephone consultation. Just give me a call, and I'm happy to chat with you. And that's it for me this evening.
Well, Anita, thank you. When it was a whirlwind. I'm sure there's a lot more questions posing out there, and I think that we may have some people that have asked some questions or might be in line. But I also want to let everyone know we are going to have a 4-hour labor law update seminar on January the 17th, so Friday. January 17th. It's going to be at Anita's office, and it's going to be from 9 to about 1. We will have a lunch break, and food will be there. But I encourage you to come to this because there's certainly been changes in the law this year that you need to be up to speed on. And then if you want a refresher on some of these things, we're going to go more in depth on them. So mark your calendars for Friday, January 17th for a labor law update, and also just back to the basics, going back through them.
Yeah.
So Jeff, do we have anyone that might have a question?
We don't have any questions that came through online. However, we do have some dentists on the phone. The lines are open. If you do have a question, you can just go ahead and ask. Just say something, and we'll see if we've got anybody on here real quick, or everybody's really shy tonight. I think we've got a shy group, Monica.
Wow. Okay. Well, Anita, you might get a few phone calls.
Yeah, we either have a shy group or we have a hungry group. It's 7 p.m., so.
There you go. Well, Anita, thanks so much. I know it's late at night, and we really appreciate you doing this. We all need to keep our minds in the right places. We're employers, not only just trying to help our patients, but that there's employer issues we've got to keep our minds on. So appreciate it, and I do hope actually some reach out to you and just get some better consultation on it.
Terrific. Thank you so much for inviting me. Enjoyed it.
Jeff, I think that wraps it up.
Okay, great. Well, again, thank you, everybody, for being on the call tonight. We'll post this on the replay. If you do have a question and you're listening on the replay, we do have the slide up there where you can reach Anita, or you can always call Monica at her office, 714, Monica?
714-619-0667.
Great. Thanks again, everybody. We'll talk to you soon.
Thanks. Good night.